You have heard it said that justice delayed is justice denied. How true that is? Well, maybe if you have been to the walls of a court, you'll probably understand. Over 2 weeks back to back, I remember on the back page of the Nigerian Tribune, Ebmolu Adegborowa over and over again talked about the failing judicial system. How far, so far about that? He's raised so many issues, and I'm sure many people would also relate with that. You know, some cases have been on since like forever, and some of them don't even have a hearing date yet. The hearing date is slated for 2021. While there are some cases, according to the law, that must be heard expeditiously. How do we resolve all of these issues and make sure that we have a reliable administrative justice system in Nigeria? That's what this conversation is about, and we have with us here in the studio Mr. Mohammed Belgore, Senior Advocate of Nigeria. Thanks very much for joining us. As well as in our Abuja studio, Mr. Osaro Ehobamie, a Senior Advocate of Nigeria as well. Thank you very much for joining us this morning, gentlemen. Let's begin here in Lagos. Mr. Belgore, first of all, are you as concerned as the man I quoted earlier about the delivery of or administration of justice, of the justice system in Nigeria?
Most definitely. Most definitely.
What is the concern you have, and why is there so much concern among the practitioners?
Well, you said it at your introduction. Justice delivery is slow. The courts are congested, and it's getting to the point in which the system might collapse if urgent steps are not taken to redress it.
You just clearly enumerated the challenges. I mean, it's as simple as that, some might think, but apparently it's not as simple as that. So what is the challenge, honestly?
No, the challenge is, the problems are well known. They're well documented. What may not be so simple are the solutions to it. The implementation, the resources with which to carry them out. That may be where there may be some difficulty. But as regards what the problem is, everybody knows that the courts are over-congested. The system is slow. Litigants sort of languish in courts for years and years. And that is not the way it should be. That is not ideal at all.
So let me give you a practical example, just so we can understand the type of situation we have on our hands. So a case started in 2009, prominent case, I'm not going to be specific. And then 6 years after, 2015, a judgment was given that the court lacks jurisdiction to hear that case. 2009, 2010, 2011 to 2015. 6 years, and the court decided that, you know what, we don't have jurisdiction to hear that case. Hearing that sort of thing, what do you think was responsible? And this is not just one. I mean, there are numerous cases like this. How did we get to this point?
Well, courts are creation of statutes, and each court is given specific powers. And a foundation of what the court does is that it must have jurisdiction to decide the matter. I don't want to get too technical here, but if a court set up to resolve commercial disputes, then ends up dealing with land disputes, then whatever that court does was done with want of jurisdiction, and it has to be set aside.
No, the issue here is not the lack of jurisdiction. It's the time it took to realize that this is not our jurisdiction. 6 years. I think that's the challenge here.
Let's quickly, go to Abuja. Let's have the opening comments of Mr. Ehobamie, Senior Advocate of Nigeria again. Well, I would assume that you are as concerned as well about the delivery of justice in Nigeria, or are you not?
Well, I think, as my former boss said, everyone is concerned. The problems are very clear. Perhaps where I depart slightly is that there is no will to deal with the problems. Some of the problems can be dealt with quite easily. The example you gave doesn't give a graphic description of the true situation. So there is a case, I think it was NNPC and Honor. It took 36 years finally to get to the Supreme Court and get back to the lower court on the simple question as to which court was empowered to deal with the issue, the question of jurisdiction that you raised. And I think it was Justice Oguntade in his valedictory session who said the courts should be of unlimited jurisdiction. That requires a slight amendment to the Constitution, which can be done. And I think the Attorney Generals and the Attorney General of the Federation, as well as the states, must take responsibility. And what do I mean by that? If an Attorney General comes in, he must prescribe the policy that he is going to pursue as far as delays are concerned, and therefore introduce a self-regulatory mechanism. And if he doesn't do that, maybe the NBA will do that for him, where he says, I'm going to reduce the delays by a certain percentage. Now, there are some infrastructural inhibitions, we understand that, but there are some that are merely constitutional. There's some that require the Law Review Commission to pronounce on certain areas that are inhibited. So there are solutions. There is a need to conduct an audit of the entirety of the problems. And the reason why you need to conduct an audit of the process and the organization is that where you introduce a solution in one part, you might be creating problems elsewhere. So if you look at the Criminal Justice Act, they've introduced some very beautiful innovations, but the infrastructure is insufficient to accommodate it. One of the introductions there is that a criminal case must go from day to day. Another is that when the witness is being interviewed, it must be done under the cover of a video recording. And these are made preconditions to a fair trial. Now, I don't think it is being complied with. But even if the courts were minded to hear the matter from day to day, the infrastructure is extremely weak. And I'm talking about physical infrastructure. I'm talking about mental infrastructure. So I think that there are many things that can be done, but I think
permit me to butt in here for a moment just to ask you something about what you just said now, that there are certain cases, for instance, maybe this is another addition, fundamental rights enforcement procedure is something that the courts ought to hear day by day, and the courts are not complying with that. But the courts have to comply with election matters within specific days. If the courts are having challenges dealing with something that is constitutional on the one hand, and they are prone to comply with some other things that are constitutional, isn't there a problem there? And what can be done to rectify that?
Okay, yes. We have some successes with the election petition. But I think you need to also appreciate the consequence, the impact that has had on civil and criminal cases. So whereas you're dealing with cases of 140 days, immediately you conclude the election petitions, the consequence is evidence. For example, we're now receiving dates in the Court of Appeal for an appeal 2 years, even though the appeal, 2 years after the appeal is due to be heard. So if a date is given to you today, and you attend the Court of Appeal, if for any reason that matter is not heard on that day, reasons that are outside your control completely, the matter will be adjourned for another 2 years. And there's no guarantee that when that matter comes up 2 years thereafter, it will be heard. And these are as a direct result of the election petitions that were heard. So what I'm saying to you is that whilst you're dealing with one issue, you are creating bigger problems. It's not even about specialized courts, because there's a lot of inefficiency in the present system, and you're going to infuse that into the specialized courts. We need to maximize what we have, understand the process, understand it through conducting an audit of both the process and the organization, and then begin to deal with the problem the way they present themselves in a holistic manner.
Well, that's definitely something that one needs to give a little bit of attention to. But very, very quickly, just before we take a break, Mr. Belgore, he says there is no will to deal with these issues. Whose will at this point?
Well, first of all, I agree with him that there is no will to deal with these issues. The thing is that nobody in the executive is generally interested in a fully independent, properly functioning judiciary. When I say nobody, I don't mean that they want to put the judiciary down, but it's not a priority.
Even on the vice president.
It is never really a priority in
Why
the
do you
sense
say
that, well, because there are legislations that they may want to pass that immediately the public will want to latch onto as performance by the government. The executive action, building roads, building hospitals, announcing job creation opportunities and things like that. Those are low-hanging fruits. Those are the things that the public immediately latch onto. So the judiciary has to be the one to drive any process of change by itself.
Okay.
Judiciary means well, but I think it needs to do a lot more.
Okay. We'll deal with some solutions when we return from this break. Please stay with us. Well, it would seem that Professor Asenua got a little emotional there, but maybe because men find it a little difficult to cry. That's why we don't see your own tears, Mr. Belgore. Do you feel the same way she does?
I feel the same way she definitely feel the same way she does. Anybody who has an interest in the way things are working, who believes in the rule of law, delivery of swift, efficient justice, must feel concerned.
Isn't there a way to compel action? This has been going on for so many years, and definitely there is concern, but there is no one really making a very, very loud noise about it. If, for instance, lawyers are as concerned as you say they are, shouldn't the Nigerian Bar Association be able to take some strong action that will compel government to do something? Shouldn't judges also have a voice?
Well, the Nigerian Bar Association, yes, I agree, can step up. Judges in various courts are doing things, but they're all piecemeal. I think what we're talking about is a wholesome institutional change. For instance, in Lagos State, they had an initiative under the last chief judge in which they were clearing a lot of cases that have been in the court's docket for a number of years, and that was effective to some extent. But what we're talking about is wholesome changes. There's some low-hanging fruits. There's some that will require constitutional reform, but there are others like the appointment of judges, for instance, the criteria for appointment of judges. Today, it will surprise you that it's more difficult to become a senior advocate than to become a judge. Now, I don't think that should be the case. Before you become a senior advocate, you have to have conducted cases in the High Court, in the Supreme Court, in the Court of Appeal and in the Supreme Court. I don't believe they ask anybody how many trials you've conducted before you become a judge. That can be addressed. The issue of putting square pegs in square holes also arises. You get a judge, someone's appointed as a judge who was probably the director of public prosecution, was a state counsel. In other words, he's been doing criminal law all his life. He then gets appointed to a commercial court. He now has to be dealing with issues of maritime law, issues of intellectual property, issues of tax. And he's seen them for the first time. So he's learning on the job. Judiciary should not be a place where you learn on the job.
Are you advocating special courts?
No, I am not advocating special courts because I think special courts has its own problems. The most obvious one is the one Osaro mentioned. The moment you create special courts, lawyers will raise issues of jurisdiction. And the law is that when you raise jurisdiction, it has to be determined before you get to the merits of the case itself.
And how long does that take?
Well, he just gave an example of one that took 39 years. You mentioned one that took 6 years. Only last week in my own office, we had 2 cases in which the issue of jurisdiction came up. So don't create special courts.
I think you also, sorry, you can land on that, because, okay, let me just say, you highlighted the role of lawyers, and I think that's something we should also touch on. You've talked about judges, but then there's also the role of lawyers, and a lot of people have said that lawyers are part of the problem, and I don't know if you would agree with that, especially, you know, filing in for adjournments when there shouldn't be adjournments, trying to stall cases, and they say that, you know what, largely, the cases of, you know, justice being delayed is because of lawyers. Do you agree with that?
I agree with that. Lawyers play a major part, but again, it's the system that allows it to happen. What are the sanctions? The rules are sufficiently lenient. So if lawyers feel, unfortunately, that they have to slow things down to confer benefit on their client, a lawyer is faced with a situation in which his client has a fairly weak case, and it's his interest to try to slow it down, to sort of, as it were, postpone the evil day. As long as the system allows him to do so, he will take advantage of that. But these are little things that can be addressed.
Okay.
And that's why I said there are low-hanging fruits, and then there are some that require constitutional reform.
Well, Mr. Hobamir, you talked the other time about some things that needs to be done as far as administration of justice is concerned in Nigeria to speed things up and make things better. You talked about things that require constitutional amendments. You talked about ones that don't require any constitutional amendment. What are some of these ones that you think can be done today, and why are they not being done?
Okay, let me approach it and deal with 3 or 4 issues. The first one I'd like to deal with is the National Judicial Council's powers. They are saddled with the responsibility to formulate broad policy regarding the administration of justice. I don't know what the policy is that's been prescribed today, but I would expect that there should be a distinction between administration of justice and administration of the court processes. An administration of the court processes which deals with the day-to-day organization of the courts. That responsibility is for the chief judge or the chief justice. Now, the chief judge may not be the most competent to deal with the administrative processes that gives rise to justice ultimately. So we expect some policy. Now, if there is a policy, we don't know. If there were to be a policy, then we'll work together as stakeholders to ensure that that policy is implemented. So I don't know what the policy is, because statements are made by the judges that they will not depend on technicality. Justice is to be efficient and, produced at the right time. But when you look at the conduct of lawyers, and when you look at the way in which judges administer justice from day to day, you find out that it's not in consonant with any policy. So there has to be a prescribed policy, and under that particular, and this is actually in the Constitution, mind you, I think it's in the 3rd schedule, where it says the NJC must, the NJC is saddled with the responsibility of prescribing policy. Now, in the absence of a policy, we are working in different directions. The second point I want to make is there was an audit carried out, I think in 1996, just before the Vision 2010 document was implemented. And I think that's a good piece of document, because when you make proposals, they should be based on empirical evidence. The 1997 document, it was signed in 97, that's Vision 2010. I don't think anyone has looked back to see how much was implemented as far as reforms are concerned in the judiciary. I sat in subcommittee of Vision 2020. I sat dealing with mortgages, subprime mortgages at that time, and what we needed to do, not in the committee dealing with judiciary. Now, that committee drew from Vision 2010, I would expect, because Vision 2020 document, I still consider it to be the best piece of legislation. Now, you can pick out of there, because what you have in Vision 2010 was based on empirical evidence. Today, we don't have any of that. we don't have any broad-based empirical evidence by which we introduce reforms. The third point is the Law Review Commission. The Law Review Commission should look at cases that are not in consonant with what we consider to be common sense. And let me explain what I mean. A case travels all the way to the Supreme Court. Takes 10, 15, whatever number of years. And then the Supreme Court, or one of the parties, and this is just reinforcing the point that my former boss made, one of the parties raises the fact that a lawyer had not properly signed the processes. And in the Supreme Court, the justices look at the processes and say, well, this is not the name by which you were enrolled, and as a result, this process is defective. One would expect that if there were any punishment to be meted out, that will be directly to the lawyer who wrongly signed. But the lawyer is simply saying, well, I am enrolled to practice law, and as a result, I need to, I am entitled to advocate and to defend this particular client or to prosecute the case. But the Supreme Court says this is a jurisdictional matter, and therefore the case is dismissed without actually going into the merits on account of the fact that a lawyer who's been called to practice, who assumes responsibility, has signed the document wrongly. Now, it appears we've taken leave of our senses because the parties went to court for their matters to be adjudicated upon, and then the court, all the way to the Supreme Court, decides that matter on the signature on that process. What does the Law Review Commission do? I don't know, nothing. Now, the Law Review Commission is there to actually intervene in these sort of cases. The point I'm making is that the courts are clogged with cases dealing with procedural jurisdiction. And the courts encourage that because they are overburdened. It's a circular problem. They are overburdened, so the merits of the cases are not entertained, so you do not have substantive justice in the way to speak. So the Supreme Court, that's otherwise a policy court, now begins to deal with very, very basic regimental matters. When we appear in the Supreme Court, the first 15 to 30 minutes, we're shuffling documents, asking whether or not there's one document there, asking what happened at the last time. No less than 15 to 20 minutes at the Supreme Court. Many of these cases, of course, should end in the Court of Appeal. Law is about analysis of facts, analysis of the evidence. So I think the NJC, the Law Review Commission, and the Attorney General can do quite a lot. And if you needed to amend the Constitution, I mean, it's not that complicated, especially as my former boss has said. These matters are not the concern of the executive. And therefore, if the Attorney Generals, and I mean around the states, and I hear they have meetings once quarterly, and they decide the sort of amendments that should be done, you need to get 3/3 of the state. That's not very complicated. It's not very difficult. And you amend it and remove all those inhibitions in the Constitution. So there are a combination of things that needed to be done, but unfortunately, as I say, even the Vision 2010 was never implemented. Vision 2020 has not been implemented. We now have a month to 2020. That's quite ironical. I think we'll perhaps reset the vision. So a country that doesn't have a vision, a country that cannot deal with the very basic issues.
I need to come in now. Let's come to Lagos. I know you've identified some of the challenges and solutions, which a lot of them actually are in the right direction. But let's ask Mr. Belgore. Now, he has said a few things, and I'd like you to help us with a game plan, because right after we've identified the problems, we put out a solution, we need to have a game plan, because this is a conversation we keep having, and I really don't want us to have this next year. And I think you share that same perspective too. So what game plan do we employ such that we start from here, move to there, and then try to solve these problems?
Well, picking up from where Osaro left off, let the heads of court deal with the procedural matters, the matters to do with procedural issues clogging up the judicial process. And they have chief judges have powers to issue practice directions. The president of the Court of Appeal has the same thing. The Chief Justice has the same powers for the Supreme Court. So they could deal with that. On the more substantive issues, which require constitutional amendment, as he said, that would require the states' attorney generals taking input from members of the bar, maybe from the judges, coming together, proposing the required constitutional amendments and pushing that through. So the game plan is fairly straightforward in how to go about it. But it's no point having a game plan if you don't even know what the game is going to be. So you got to decide what the game is going to be. What are the changes you want to make?
Forgive me, sir. Who should champion this game plan?
I don't think it should be any particular person. Everybody in the administration of justice should be interested in it. But I would say that the Bar Association, if I were the president of the Nigerian Bar Association, I would champion it. Because the bar is the one who is in touch on a day-to-day basis. The judges, yes, want to effect change. The chief judge wants to effect change, but the chief judge is already bogged down with their own immediate problems within their courts.
Do they have the autonomy or the authority to champion these things themselves? I mean, I'm talking about the judiciary.
Yes, the judiciary has all the powers to champion it. But the ones that require legislation, obviously, they will have to put legislation forward.
The ones that do not require legislation, I don't know if they require legislation to build more courts or engage new judges, if that's what it's going to take, because I'm sure you're aware of more than 10,000 cases, you know, that we hear are outstanding in cases in courts that have not been dealt with, and I think that's just for high courts. I don't know how many are there in the Supreme Court and all of that. So if the judges are as concerned as you say they are, and they can do something about it, what's stopping them?
Well, like I said, there has to be some institutional change, for instance. For instance, I would say that let's have a system of a part-time judiciary. They have it in the UK. We borrowed a law from the UK. This is a practice by which senior lawyers apply for consideration to serve as part-time judges. Now, in the UK, a part-time judge can do everything a full-time judge can do, i.e. delivers judgment. When you apply and you are selected, you must commit to at least a month of judicial work. Now, this will help in clearing backlog. Now, in Nigeria, you may say, okay, that's too drastic. We can't go there yet. Ultimately, we should get there, but we can start off in which these part-time judges will clear all the procedural issues. As you well know, if I go to court on the basis that somebody has sued me and I want my money back, now, what I want is my money back, and that is what I want the court to decide. But before the court gets there, there may be so many issues along the way. I'll be given time to present my case. He may argue that I brought in something that should not have been brought in. Somebody, the bank, should have been joined in the action. All these procedural matters, they take a long time. The actual trial itself may just be for like 2-3 days, but the procedural matters could go on for years. If you have this system of part-time judges, experienced legal practitioners, they clear up
and that will need
these things. But that will require constitutional amendment. But I would not imagine that there should be much opposition to it. And if there's the will, it can be done.
Just quickly before we take a break, Mr. Hobamia, do you agree with this? Do you think it's something that should be considered? Part-time judges to clear the backlog?
I think it couldn't have been put better. It's not just part-time judges, actually, it's said part-time practitioners, senior practitioners. And what that does, especially in the UK, is it gives you an opportunity to test the capabilities and competence of that person and whether or not he should then go to the bench fully. There is no procedure for investigating the integrity and the intellectual rigor here before you actually get into the bench. So there's the pedestrian qualifications. That also delays some cases because there are many cases and many procedural issues that can be dealt with because the court is in control. But because of an absence of depth sometimes, you find that these matters are adjourned over and over again for research and learning, whereas that should be in the forefront. So what you have with those sort of the sort of intervention that Mr. Belgore was suggesting, what you then have is that if senior lawyers who are interested in going to the bench, and I think that's very important, were to be permitted to conduct these proceedings relating to procedural issues to clear the backlog, you would have an opportunity to assess the level of intellect and rigor and behavior of those who go to the bench. So I think it is fundamental, and it's not that difficult. Look, when I was growing up, I traveled.
Mr. Hobame, just one moment. I just wanted to take your view on that one, but thank you very much. We'll be back to close this segment in a little while, so please stay with us. Gentlemen, we have just 1 minute for each of you to give us your closing comments, and it's just one question. Please give us an interpretation of this judgment by Justice Oguntoyinbo about the governor's jumbo pay. Some say that the court has ordered the federal government to refund, to get a refund of the pensions that the governors have gotten over the years. Some are saying that the court is telling the Attorney General of the Federation to take it on. You know, what do you think the judgment says? Well,
by my training, really, I wouldn't want to comment publicly on a judgment that I haven't read. So I'm sorry to disappoint you. I'm no better than you on this. All I know of it is really what I have read.
But one of the things
what I've read in the newspaper. So I haven't read it, and I'll be slow to comment on what you actually said.
Do you think it is legal? Because the justice said that it's not constitutional. It's illegal for the states to have done that. Meanwhile, the Constitution says that the Houses of Assembly may enact pension laws.
Well, I think you have to know the provisions that were being interpreted to determine that issue of legality. I'm not being evasive, but I just haven't read it, and I can't give an intelligent comment on that.
Let's ask Mr. Ehobamie if he has seen it or what his take is on that judgment of Justice Oguntoyinbo.
I think I stand on all squares with where Mr. Belgore also stands. I haven't read it, and you should be careful to take any opinions from any of us if we say we haven't read it and we've been invited to discuss reforms in the justice system. Let me conclude like this. Lagos State actually introduced substantive reforms. When I started in practice, early 90s in Nigeria, I used to sit before the courts where you had 150 cases. I remember before Justice Adagun. Lagos State did fundamentally well. And you ask the question, who takes responsibility? The Attorney General and the Solicitor General, in the person of, I think, now the Vice President, Anna Faware. They did a fantastic job reducing the delays, introducing substantial changes. So the Attorney General must take responsibility. You ask who? And I expect that the Attorney General should introduce a system where he is judged and his performance is judged by what he does with the delay in justice system. He's gone to the House of Assembly, the National Assembly, to give his resume as to why he's qualified for that job.
Mr. Ehobamie, we really have to go. We are completely out of time, but we have to thank you very, very much for the novel perspectives that you've brought to our conversation this morning. Mr. Osaro Ehobamie is a senior advocate of Nigeria. Thank you very much for coming, as well as Mr. Mohammed Belgore, senior advocate of Nigeria, who Mr. Ehobamie calls his former boss. Thank you very much for being a part of this conversation. And that's been Sunrise Daily today. Have a wonderful day. I'm Ayo Makinde.
And I'm Kayode Kikelu. Thank you for joining us.